Right. Well, welcome everyone. Thanks for coming. Tonight's CPD is on mediation strategies. My name's Adam Castleton. I'm one of the Silks here, along with Ian, one of tonight's speakers. Throughout February and March of this year, Greenway will be conducting a CPD super series covering a broad range of topics. I invite you to have a look at our web page if anything takes your fancy. Please RSVP and come along. We have two speakers tonight, Ian Roberts of Senior Counsel and Adele Carr. Ian tells me that he's an Aries, his favourite colour is blue, and he really just wants world peace so everyone can be happy. He also practiced as a barrister for the last 23 years. Before coming to the bar, Ian was a solicitor here in New South Wales and also in Queensland. We won't hold that against him. As a practising solicitor in the early 1990s, Ian saw firsthand the early days of mediation in the litigation context. Ian has appeared for both plaintiffs and defendants at mediations, and as an accredited mediator has seen the do's and don'ts from that perspective as well. Adele, I'm told, is a Virgo. She likes cricket and is not particularly fond of long walks on the beach. Before coming to the bar, Adele practiced as a solicitor here in New South Wales and in South Australia. I'm not sure what it is with interstate practitioners coming to these chambers, but in any event. She's also participated in mediations in various state jurisdictions as well as federally, and has also written journal articles regarding the effective use of mediation. In today's legal landscape, it's hard to imagine a litigator not being involved in the mediation process at some point in their career. And it's even harder to imagine a civil dispute that does not go to mediation before its final resolution or determination. In that context, Ian and Adele propose to deal with some aspects of mediations that are often misunderstood or ignored, and provide some tips to use the opportunity more, that is, to use the process of mediation more effectively. I'll call on Ian to speak first. Over to you, Ian.
Thanks, Adam, and welcome everybody. We thought that this would be a useful topic for a CPD, not so much because mediations are new and people are unfamiliar with them, quite the opposite. They've been around for ages, we're all familiar with them, and there's a tendency in those circumstances sometimes to be a bit blasé about them and just roll your arm over. And we think that it's really important to continually reassess your performance at things like mediations, critique yourself, make sure that you're doing the best you can for your clients. And as Adam said, it's hard to imagine being involved in litigation and avoiding mediations these days, because most courts, if not all courts, at some point will raise the question, if not require you to mediate. And in most cases, you'll probably want to do that yourselves voluntarily. But it's hard to imagine a time, but even during my relatively short professional life, when litigation was not case managed. And I started to think about why mediation became popular in about the late 80s and early 90s. And I think it was because it coincided with the time when case management started to come in. Prior to case management, and even when I started as an article clerk, litigation went on for decades. Nothing ever happened in cases. They just dragged along at their own pace. And even when years later you actually got to a trial, or got set down for trial, most of the time you'd be not reached a couple of times before you actually got before a judge. Case management compressed all that into a very short time frame. And I think what that did is require people to focus on the cost of litigation, because what was spent over many, many years was suddenly being spent in a very short time frame, and people started to think, well, there must be better ways to do this. And that's, I think, what was the driver for the popularity of mediation in the late 80s, early 90s. And it's developed over a period of time, and we now have a large number of mediators who, some of them, do nothing other than mediations as mediators. So people are becoming professional mediators, the techniques are being refined and so on. Now, as I said, very few cases are unsuitable for mediation. But rather than consider whether or not something should be mediated, I think the question you should be asking is, when should they be mediated? The timing of when a case is suitable for mediation is quite an important question that you should consider. As in virtually everything in life, timing is everything. like the timing of this screen change. Look at that. Had I got up a little bit earlier, things might have turned out a little bit different on Bob and Head, and I think Mark Hilton was probably with me on the day that I took that photo. Now, when should you mediate? That'll depend on a number of things. They're the sorts of things it will depend on. The important thing is to consider the question. Many people just get to a point in the litigation and say, well, we should mediate. Well, is that the right time to do it? You really need to reassess that, having regard to a range of different things. The question will, every dispute will be different, but the question will require you to consider a tension between two competing desires, having regard to a number of things. Effectively, you've got the desire to have an informed decision. To have an informed decision, you need as much information, as much knowledge about the case, and in particular, as much knowledge about the other side's case as you can get. That takes time. The longer a case goes on and the more information you gather, the more costs you are going to incur. So the other desire that everyone has is to keep the costs down, and that's why you try and mediate, to avoid the cost of litigation or reduce the cost of litigation. But those things are in conflict. So you've got to pick a point in time when you've got enough information to allow you to have an informed decision to mediate and to settle, but you haven't gone so far down the track that you've spent so much money you're beyond settling and parties start to become entrenched in their positions. So it's a bit of a cost-benefit analysis that you need to undertake in determining what is the best time to bring a case to mediation. And that's the law of diminishing returns. You get to a point where the additional information you get is going to be outweighed by the costs that you're going to incur in getting it. But as I said, the important thing is to focus on the question. If you consider the question, the criteria that you'll have to take into account in answering it will become obvious, and the question will be able to be answered, but it depends on each and every case. Now, sorry, that's something that Adele is going to deal with I think. Yes, sorry. Adele's going to look at the first stage of the mediation process, that is the preliminary conference.
Once the parties have elected to attend mediation, the next step is preparation, and you might be familiar with the Law Councils of Australia guidelines for mediation, and one of the guidelines relates to preparation, and it states, preparation for mediation is as important as preparing for a trial. A lawyer should look beyond the legal issues and consider the dispute in a broader, practical and commercial context. This is a little bit like the overarching principle that we see in the UCPR. It's an overarching principle but doesn't really provide much guidance as to how you should go about preparing for a mediation. However, the start of the process are preliminary conferences. Usually these are held with the mediator. It might be with your party as the legal representative. Usually it's also conducted at the convenience of the parties, probably a few days to a few weeks before the mediation. At the preliminary conference, this is an essential time to discuss a number of issues to make sure that the mediation doesn't derail. And these are a number of the issues that I'll go through now. One of the first important issues is who is coming. Now, this can be quite straightforward when a party is an individual. When it is a group or it is a company, you'll need to consider whether a director, an executive or an in-house counsel turn up, particularly with strata, so owners corporations, and we're now seeing a lot of that come through in the building and property space, whether the executive committee or one person will be turning up. It also will depend on who might turn up, if there might be some support people or some additional people in the room. If it's a particularly emotional dispute that's occurred, someone might want a support person. If there's a language barrier, an interpreter. If it needs to require an expert, maybe an accountant or a building expert. The other question is, if a legal representative attends, what capacity will you be attending? And there have been identified in some academic journals particular roles that legal representatives might play. One is an absent advisor, and they are there to assist the client to prepare, but they don't attend the mediation. The second is an advisor observer. They attend the mediation, but they don't participate. The third is an expert contributor. They participate to the extent necessary to give advice. The fourth is a supportive professional. They directly participate in the mediation. And the fifth is the spokesperson, which I'm sure some of you would be familiar with. The next issue is who has authority. Unless the party is an individual, again, this can be straightforward, but when you get to owners, corporations and companies, can become quite difficult. The scope of the authority is essential as well, particularly where there are limits in monetary value. It's essential that the person does have the scope to resolve the issue. Otherwise, if they need to make a phone call, then you need to make sure that that person's not on a plane at the time that the mediation's being held. Who will sign any agreement that might be reached? Again, that this is important with respect to an owner's corporation and a company as well. Who are the representatives? Again, although this does look a link back to legal representatives, it's really pertinent when there is a large group. And particularly if there's a group of 10 or 20 people who are a party, some people might want to be a speaker, and you might want to outline who might be speaking or in opening statements. What are the issues in the dispute? As lawyers, we can quickly identify, usually as we're trained, the legal issues in the dispute, particularly once the dispute has been going on for some time. The difficulty can be is isolating the non-legal issues, and it might be the commercial realities. Otherwise, parts of the non-legal issues relate to parties' needs. And indeed, by deconstructing a dispute with respect to a party's needs as opposed to their wants, can create an environment where you can look at resolving a dispute beyond the legal issues. To identify needs can sometimes be quite difficult, particularly where parties are directing, I want that company or I want that property. Needs versus wants is something that has been considered in principled negotiation, and a very simple example of needs versus wants is where two children want a Mars bar. One child wants the whole Mars bar, the other child wants the whole Mars bar. You take one child to the side and say, why would you like the whole Mars bar? The child says, I want it because I want to completely eat the Mars bar. You take the other child aside and say, why do you want the whole Mars bar? They'll say, I want the whole wrapper because inside there is a competition and I want to enter the wrapper into the competition. So indeed, by identifying the need of the Mars bar versus the wants, you can create unique solutions to a problem. The next one is how will agreements that is reached be documented? We'll be going through later on in the seminar how to document and when to document resolutions that might be reached in a mediation. But what's essential is at this point in time in the preliminary conference is to consider, will you be bringing templates? Will you be maybe writing or considering the clauses that might be within a settlement agreement? I attended a mediation once where the other side had a template already ready to go to insert the dollar amount. It took 4 hours to reach a negotiated settlement. It then took 4 hours to then overcome the template agreement that we had. So it needs to be, all the parties need to be flexible with the terms of any settlement agreement. The next to consider before going to mediations is position papers. Now, position papers are sometimes the first opportunity that parties can deliver to the other side their interpretation of the dispute. And in that sense, position papers should again be directed towards a party's perception of the dispute, not necessarily their legal rights or their obligations. Particularly with the position papers, there is sometimes a need to identify some legal issues, particularly where there might be limitation periods or joinder of parties. Otherwise, really position papers should be geared towards explaining to the other side the party's perception of the dispute and trying to invoke the other side of creative ways to resolve the dispute. What is essential in also the position paper is the style of it. Although this can be individual, it shouldn't necessarily be lengthy or discursive as well. Particularly also with position papers is that this is the time before the mediation commences, so it effectively sets the tone. So that's important to consider when drafting a position paper. And we're now on to opening statements, which Ian will go to.
Thank you. This is a little bit contentious because sometimes parties are tempted to ditch them. And I've been at many mediations where people have come up, both as a mediator and as an advocate, and people have come up to me and said, look, we all know the case, we don't need opening statements, let's just get on with it. And even some of the more experienced mediators, Kevin Lindgren, for example, is one very experienced mediator, is not a big fan of them. With respect to Kevin and others who take that view, I don't agree with that. I think that approach tends to ignore or misunderstand the purpose of the opening statement and the opportunity that it presents. I've set there in the slide what opportunity that is. This is going to be probably the only opportunity, it certainly will be the first, but probably the only opportunity for you as a representative of a party to look across the table at the very person who's affected by this case and stare them in the eyes and explain to them why there are good reasons for a settlement to be achieved there and then rather than proceed on to trial. And there are often things that they can't glean from the evidence or from the pleadings. There might be things like the effect of the litigation on ongoing relationships, both commercial and personal relationships. You could explain things such as the opportunities for thinking outside the square, agreements that can't be provided for in a judgment. There's much more flexibility in a mediation, and this is an opportunity for you to not present to a third-party judge or a mediator or even your opposite number. This is an opportunity for you to look at the actual party and speak to them directly. So it's a very important opportunity. What it's not is a submission. I can confidently say no one has ever thrown in the towel having heard the opening statement of the opposite number. It's not an opportunity to get on the soapbox and grandstand how great your case is, how you're going to win every point, every factual point, the legal points are with you and all that. It just doesn't happen that way. And it's also not the opportunity to tediously take a mediator or the other side through in detail every aspect of the pleaded case and all the intricacies of the evidence. There are some aspects, no doubt, that you're going to have to explain and take people to, but it's not an opening statement in the form that you would present to a judge. You need to work out who is going to be affected by the litigation, who's going to make the decision, because that's your audience. It's not your opposite number. If you're a barrister, it's not the barrister on the other side. If you're a solicitor, it's not the solicitor on the other side. You've all probably seen mediations where there's an opening session and the barrister or the solicitor sits down and they stare at their opponent across the table and they look at them aggressively and they thump the table and they say, we're going to win, we're going to do this. And they go on and on about how great their case is. It's like they're doing some sort of verbal haka. You know, they're just trying to convince the other side. The other barrister or the other solicitor doesn't make the decision. They might be providing some advice, but they're not the ones that you're trying to persuade. The person you're trying to persuade is the party sitting down the table a bit, and they're the ones you should be focusing on, not some legal submission to try and persuade your opposite number or even the mediator. The mediator doesn't care. They're not going to make a decision. Now, it's correct that you've got to, from time to time, go through a bit of detail. There's a balance. You've got to find what is the best way to provide enough detail, enough of an explanation of the case that doesn't completely overdo the situation, so it allows you to explain to the person who's going to make the decision what it's all about and why settlement on particular terms is a good option for them at that time. Now I'm going to deal with multi-party litigation because it presents particular challenges, and to be fair, most commercial disputes involve a number of parties, but there are particular things you need to be aware of in a multi-party dispute that is mediated. There are different relationships between different parties. There may be financiers, insurers, the insured, other parties, other defendants, other plaintiffs and so on, all people with disparate interests. You need to identify who's who in the zoo. You've got to work out who's got the money, who's going to make the decision. Are there people whose position is contingent on other people and other people doing certain things or other agreements that might be entered into? So you've got to focus on that to identify your overall strategy. Now that's something that probably should be done at an early stage, and Adele's talked about the importance of the prelim conference, and that's a good opportunity to do that. Everyone who's going to participate in the mediation ought to be there. You understand probably from the litigation generally who has what role, but it's probably an opportunity for the first time to see everyone in a room and see who the movers and shakers are. Who's going to be the person driving on the defendant's side, for example, how the mediation is going to proceed. Certainly by the time you get into the mediation with a multi-party dispute, you need to have a good understanding of the parties who are going to drive it, the parties who are going to pay the money, who's going to make a decision and who's going to follow. You also need to keep an eye out for what I call the sleeper party. The sleeper party, you've all seen them. They're the party who sit down in their breakout room, reading the paper, ordering coffee. They've always got the best lunch order. They don't take any part in the mediation, the negotiations. They sit there and they watch the action, to the extent you can call it that. And they let all the negotiations proceed to a point where you think you're starting to put everything in place and the ducks are starting to line up, and then they stand up and say, oh, but we're not going to take a settlement involving that. And they start to unrail or derail the whole exercise and do more harm than good to the work you've done up to that point. I think the way to deal with them is to keep them involved, keep them informed throughout the process. There are always going to be cases where you've got to focus on the movers and shakers. You've got to focus on the person making the decision, the person with the money or the party with the money. But you can't forget the sleepers. You can't forget the other people. You've got to keep an eye on who's who, what they're doing. Just tell them if they're just going to be involved only at a certain time, tell them, I've got to deal with this person first. I'll come back to you in 20 minutes. Is that all right? Get a coffee if you like. This is what we're doing. This is where we've got to at this point. If you do that, it's less likely that they're going to wait until the end of the day and say, now, I've got a problem with that proposal. If they've had the opportunity to speak throughout the exercise, then they're less likely to cause a problem at the end. I think one important issue when you're starting to put together the resolution, the proposals and so on, is to make sure that you're not doing something that's just unachievable, and Adele's going to deal with the importance of structuring an achievable outcome in the mediation.
Once you've done all the hard yards, the last thing you want is for the mediation to completely derail because what you thought and sounds and looks like a great resolution actually isn't workable outside of the mediation room. In that sense, it's really good to workshop ideas that you've come to, and indeed bounce ideas off for the parties yourselves, the legal representatives, and maybe even if the mediator has any comments about how this resolution is going to work outside of the mediation room. I was involved in a mediation where there were 6 parties, and one party came to the mediation with a proposal. It was an exceptional proposal which had the potential potential of resolving the dispute probably more than half. It had been extended Supreme Court litigation going on for years. What the proposal entailed was for one particular party to do some tasks. The results of those tasks would then be given to a third party. That third party would then perform their own tasks. Those results would then be passed on to another third party. Although it seems quite obscure, what we thought was something that was airtight. The four parties who were not sort of engaged in this potential settlement negotiation, we sat on the periphery, hoping that once one of the parties had done their tasks, we said some Hail Marys once it went to the expert. The difficulty came once we had signed some heads of agreement for this to occur. It fell over within days. And the reason why is because the party who thought that they could perform these tasks outside the mediation room couldn't. They didn't have the means to, they didn't have the authority to, and they didn't have the scope to. And what it ended up resulting in was us going up to the Supreme Court on a notice of motion with the first party who proposed this potential agreement to put it back on foot. And then when, as you know, if it does go up to the Supreme Court on a notice of motion, you then have to go back and have a look what happened in the mediation room, which is never desirable for anyone. Documenting settlement and mediation agreements leads into the next slide, where it's essential to completely document all of the agreement, not some of the agreement, not part of the agreement, and particularly not even just a heads of agreement. The reason being is because once you leave the mediation room, nothing is transcribed. This is not a courtroom. Everybody will have different notes to what happened. Everyone will have different thoughts and perceptions of what was discussed. It's essential that you then resolve the words, the express terms of the agreement then and there. If you do have parties who want to celebrate early and go to lunch, keep them there, nut out the agreement, and then go and have a celebratory dinner. It will be better than leaving for a couple of days where the results of the mediation might fall over, or you might have to go back and try and nut out another agreement. Ian will now talk about ethical issues.
Just before I do that, though, the importance of documenting and finalising the agreement. I was in a mediation many years ago. I think Richard Cheney was representing one of the parties, and we reached an agreement relatively early for a mediation. It was just before lunch. And our mediator, who shall remain nameless, just said, "Oh, well, you've sorted it out. Give me a ring if you need anything," and I'm off. It just took off. Within an hour, the whole thing had started to unravel, and by 3 o'clock, we thought we've got to get him back, but it's just coming apart at the seams. But he was off on a boozy lunch. We couldn't find him. So it's not over until it's over. You've got to finalise it, document it, and have everything signed off. Another one I wasn't involved in the mediation, but I had to mediate a dispute about what the heads of agreement meant, because they come up with a heads of agreement. Mediation went all day and all night, and by the time they'd agreed on something, everyone was too tired to really look at it seriously about documenting the agreement. So they nutted out a heads of agreement, and then there was this massive dispute about what it meant. So there was a second mediation just to understand come to an agreement what the heads of agreement meant. I mean, that's not all that uncommon, those sorts of things, when things aren't documented properly at the mediation. Ed and Morris have both been involved in a case that had to have a second round of mediations, a case we were both in, or all of us were in, because I can't even remember what went pear-shaped. Thankfully, while they were mediating, I was skiing, so it wasn't so bad in the end. But yeah, that just emphasises the importance of making sure it's all properly documented and everyone understands what the nature of the agreement is. Now, some ethical issues. Everyone's familiar with the requirement to maintain confidentiality in a mediation. It's not new. It's normally part of the mediation agreement that the parties sign. It requires everything that goes on tour to stay on tour. Parties also, or mediators normally also have the non-party participants sign a confidentiality undertaking, and I do that as well. I think, to be honest, the obligations as lawyers would require us to maintain confidence without us signing a confidentiality undertaking, but it's not so much for the lawyers and to keep them honest, it's for the benefit of the client, who will see that that person is being required to sign a document to maintain the confidentiality of the mediation, and it's that perception that's important. But there are also confidentiality issues or ethical issues within the mediation itself, and they often arise in the multi-party litigation and mediations, because there's often, in those cases, discussions and negotiations between some parties but not others. There'll be issues disclosed, matters disclosed to one party but can't be passed on to another party. And so it's very important to keep in mind who's being told what and who's able to know what information, what can be disclosed to other parties. The other problem that arises in these types of disputes in mediations involves or arises out of the close proximity within which we all work. If we're in a mediation centre, normally there's a big room for the group sessions and everyone's got their individual breakout rooms, but there's constantly discussions, negotiations, documents passing between people, discussions in the hallway, in the open areas and so on. There is a tendency sometimes for you to inadvertently overhear something. You need to understand, you need to appreciate that some things aren't meant for your ears. You've got to, if you see that going on, you've got to make sure you move away. If you inadvertently hear something, you can't use it, obviously. I mean, these aren't all, earth-shattering propositions. These are things that you would know, but it's important to be conscious of that and the risk that you may inadvertently see or hear something in that environment, because there are so many people working in all different directions in a very relatively small space. I mean, one would think that the proposition that ought to be maintained, the confidentiality ought to be maintained, and what you ought to do in those situations would be obvious. I was in a mediation only last year, and there were a number of different parties involved. We had prepared, we had a quantity surveyor prepare some costings for rectification work, but the proposal to rectify had moved on, so it was a different scope. So the rectification costing wasn't really all that relevant. We were approached by the plaintiff, the solicitor, and he said, I understand you've got some costings, can we see them? I said, I'm not instructed to disclose them because they're not really all that relevant. They're dealing with a different methodology of rectification, so it's going to cause more problems than it cures, so let's just ignore it. Negotiations proceeded for the rest of the day, and at some point towards the end, the solicitor came to us and he said, right, this is my final position. We're going to take X dollars, which was coincidentally the amount of our costing. And he said, and I know you've got that much money because when I came in to make an earlier offer, I saw it on your costings on the table. Now, that's well and truly over the line in my view. That's not something that you would want to be doing in your professional capacity. If you inadvertently see something, you probably ought to disclose it. Say, look, you've got that on the table. That's obviously not meant for my eyes. So I think you should say something about that. Ultimately, it's common sense. I mean, you will appreciate where the line is and whether you're entitled to know something, because we don't act on things that we discover inadvertently or secretly or in some way that we know we ought not know. So you ought to be able to determine that issue just from your own experience and common sense, I suspect. The last topic that we're going to deal with before we open it up for some questions concerns the use of technology in mediations. And there you go. And Adele's going to deal with that because she's more technologically advanced than I am.
Says Ian using an iPad as well. And paper. Electronic mediations have actually been around since the 1990s, so this isn't a new phenomenon, but what we are seeing are now different platforms of mediation being used online. Indeed, eBay and PayPal have been using electronic mediation on online platforms with some artificial intelligence sitting behind it. The two platforms, though, that I'd just like to explore and some of the pitfalls with them. One is where there is someone who's sitting behind, so it's not obviously some algorithm, where the mediation is actually performed over email. The benefit of this is that there can be a delay when people are putting forward their positions, their interests, also any offers. These can be considered overnight. The downside with it is that obviously it can give the perception that the other party and side doesn't care, particularly if they take longer than a few hours or minutes, or as we now like to have instant messaging. The other type of platform that is also being used is one where it's effectively like FaceTime. So you have a screen, you'll have sort of blocks at the bottom, and you'll have the mediator and parties. Now, this is a good platform to use, particularly where there's different time zones. People can be in their offices, maybe in their pajamas at home. The downside to this particular platform using, though, what I've seen is where of the breakout rooms, that otherwise it's effectively like a negotiation, whereas with mediation, what parts of the element that people are drawn towards are the breakout and the private sessions. When these occur on this particular platforms that I've seen, the screen for the person who is not part of the private session goes blank. And no one wants to see a blank screen. You don't know how long the screen's going to be blank for, and there's no way of communicating with the mediator. So although that there are some attributes to these particular platforms, there certainly are some downsides that do need to be considered. I've also included as a topic the Civil Resolution Tribunal in Canada. This is a online dispute resolution method as well. What it allows for is small claims, so not small claims that we have here in New South Wales, but $5,000, or strata disputes, and any dispute between owners, tenants, and the executive committee. The platform allows for someone to register the dispute. It then goes into some database, somebody picks it up. Again, it's not artificial intelligence. Someone at the end looks at it. They then issue a dispute resolution notice to the other person. The two parties then have the ability to negotiate through private chat. I understand, looking at this, that it's not recorded, so that the parties can freely communicate between themselves. If they can't resolve the dispute, it then goes to facilitation. Again, someone sitting behind on their computer and assisting the parties, where they then ask for particular documents to be submitted to them, and they try and help the parties. If they can't resolve the issue, then it goes to a tribunal. It's unclear from what I can see if the facilitator is also then acts as the tribunal member. You'd assume probably not. Then hopefully then the dispute will be resolved, a decision is issued, then an order is made, which effectively is like a court order. And again, like some of our statutory tribunals here, to then appeal that goes to one of the superior courts in Canada. So this is a sort of a new online system that has been used. It appears to be that it's been quite effective and has been in use for the last 3 years. The last point is the New South Wales Government's Civil Justice Strategy. In the middle of last year, there was an announcement made for $7 million to be injected into our justice system, and part of that, it's meant to be spent over 4 years to include an online dispute resolution system in our Supreme Court. This is quite different to the online court that I'm sure a lot of you are familiar with, where you put forward your orders, effectively like going to chambers, and then orders are made on the online system and sent back. No other details have been provided as to what this dispute resolution platform might be, but hopefully in the next few months the government might release some more details about it, given the amount of money that has been announced. Oh, I'm not quite sure if we want pictures of us, but there's some questions.
Can I just say something about that? I'm sure that the technology will reach a point where we become used to the sort of electronic mediation. I don't know if it's there yet, but one thing that one disadvantage I think is it's really important to have people in the same room to talk to them, to eyeball them, to see what, assess what they might be like in a witness box and so on. And there's nothing worse than having a mediation where the decision maker is a London underwriter who at a critical time has gone to bed or has gone to dinner or something, and you can't get hold of them. It's all very well having people hooked up via FaceTime style e-platform, and it'll come, no doubt, like everything else. But I think it's critical, if you want to settle some of the more complex matters, to have people there dealing with things face to face. As I said, it'll happen, but I'm not sure if it's there yet. Time zones are a real problem, particularly with decision makers being remote. The other thing is the decision makers can so easily just say, "Oh no, give them, make an offer about X, Y, Z," and you think that's just not realistic, having regard to where we've got to in this mediation so far. They don't see the way that the mediation's developed, the dynamics of the interrelationship between the parties and how they've negotiated. They sit back and they get a call saying, "We need instructions to offer X," and they go, "No, I'm not going to offer X. Just give them Y." So I think it's critical that people be physically present to the extent they're able to in mediations. We're going to.
Yeah. Thanks, Ian. Thanks, Adele, for your instructive and insightful comments. Before we break for some light refreshments, I thought I'd open up the floor to some questions, and I might get the ball rolling by asking this one without notice to Ian and Adele. What are your views when a mediator suggests that he or she wants to meet with the decision makers, that is the parties, in the absence of their lawyers?
I think it probably depends on the nature of the case and the nature of the mediator. But I think if you're approached by the mediator and asked that, it's something that for instructions you need to raise it with the client. Some clients will be uncomfortable doing that, and some clients will be happy to do it, particularly professional litigators, insurers and banks and so on. But many unsophisticated litigants won't be happy to sit there with the mediator, no matter how much confidence they may have in the mediator's ability as a mediator. So I think it's how long's a piece of string, to be honest. But it's something that happens often, almost invariably in mediations, more and more. And it's not a bad way of breaking through a barrier when parties are at loggerheads and a mediator perceives that, look, the reason why they're not moving is they're getting some advice, and they may not have thought about a few different aspects and different possibilities. So it's not a bad way of dealing with that sort of situation, but I think it needs to be thought through carefully, and it's certainly something that the parties themselves have to be comfortable with.
Any other questions?
I've got a question. I had a mediation last week interstate, and after having been doing this for quite a lot of years, the first time ever in a mediation where the mediator did a mediator's bid.
Did it what?
A mediator's bid.
Bid?
Yes.
What's-
I've never come across. She claims it wasn't a Queensland thing, and it's a strategy in mediation.
Hang on, no.
I've never.
It's a mediator's bid.
I've never.
It's a mediator's bid.
So the
So-
mediator will suggest to the two parties that
Yeah.
they might both want to make or accept an offer in that number. And
Yes.
so
Oh,
if
sorry.
the parties get to
Yeah.
an obvious midpoint, neither of them are prepared to say split the
Not really a
difference.
bid, it's
Just suggested
It's
setup.
called
Yeah.
the mediator's bid, and so pretty much the parties then just, you indicate to her whether you're prepared to accept it. But if someone decides they don't, she just says, and it was a multi-party matter.
Yeah.
And she would say, well, if someone said no, then it would just be a case of the offer, the mediator's bid hasn't been accepted, and you don't know who it was that didn't accept the offer.
Right. No, I wasn't familiar with the term that you used, but that process, I've been involved in mediations where the mediator's done that. Kevin Lingwood did it recently. I don't know if it gets anyone anywhere, to be honest. I mean, if you are apart by a certain amount of money, how does it help for the mediator to suggest a figure if you can't?
Her rationale for it was that she said it was more for the benefit of the plaintiff, that if the plaintiff wouldn't accept an offer coming from the defendants, but if the plaintiff, if an independent person told the plaintiff by way of the mediator's bid that's what they thought the case was worth, the plaintiff might be more inclined to accept it.
Yeah, that's dangerously strained outside the.
Not exactly impartial like this.
Yeah, but that was in Queensland, was it?
I've had a mediator say something along the lines of, you know, if I was to get the other side to put an offer like this, would I be able to indicate to them that you would accept it? I've had that.
Yes, but not actually just making a bid.
And that's essentially the same process. It's actually the same thing, really. Because what you're basically saying to each person is, if I can get everyone to agree on this figure, will you accept it? I just have never heard the term.
But and it doesn't, you don't get any notice either. She just became to a
Well, the other side doesn't know what the figure is, presumably. So the mediator will go to them and say, well, I assume the mediator put the figure to the party.
Yeah, so the mediator just came to us and said, okay, I'm doing mediator's bid, it's X. And so no notice, no forewarning or anything like
Yeah.
that. That's the figure. And then
Yeah, I think that's fraught with danger, I would have thought. But
Did it work? In this case, it actually did. But
yeah, there are some different practices in different jurisdictions. When things were in the very early days, it was probably in the late, probably about 1989, 90, the Supreme Court in Queensland used to have judges of the commercial causes list, which, as it was then called, come down from the bench, sit on the other side of the bar table, take the wig off and mediate with us as the mediator, and then say, oh, well, it didn't settle, put the wig back on and go back up onto the bench. It didn't last long, that process. It was bizarre.
On that comment, you said more about a mediator speaking to your client without you being. What possible scenario would you ever recommend that to your client? Like, wouldn't
if-
it be something if a mediator, why can't a mediator just say what they want to say to them in front of you?
I think it's to try and get the client comfortable enough to say what they really think about it, not inhibited by what the solicitor might think about or the lawyer might think about that.
Can I just interject there? I've had it where it was certainly clear to me and to the mediator, who was a very experienced mediator, an ex-judge, that the other party was getting bad legal advice. And it was used as a way to cut through that. I had no problems advising my client to go into that meeting because I knew that they weren't going to be the subject of anything that would trouble me, and I had confidence in their sophistication and education and whatnot. But the problem was that we all formed a view that the advice that was being provided to the other party was wrong, and that was the wall that we couldn't get around or go through.
Why couldn't that not be said to the
Well, I don't know what took place. I don't know what took place between the mediator
Yeah.
and the other side, but it got to the point where that was the suggestion that was made to try and overcome that problem. And to my surprise, the other side agreed.
Okay.
And they went off into a room together without the lawyers, and they reached a settlement.
But in terms of your question, when would you advise or recommend to your client to do it? You'd have to be confident that your client was in the position of Adams, that they were the sophisticated, confident litigator, and they needed to do that, put themselves at risk by dealing with the mediator directly, so that the other side would do the same thing. But that does happen when you think that the advice that's being given is the real barrier to settlement. Ultimately, though, most parties will discuss things with the mediator in private and then go back and say, well, this is what he said, what do you think? And they'll ultimately get advice from the lawyers anyway, so sometimes and often it doesn't actually achieve anything. But every now and again it does. Anyone else? Yep.
I mean, obviously, multi-party mediations present a lot more challenges and complexities than mediation with two parties. Do you have any tips or sort of universal truths that you think apply to multi-party mediations, or especially in circumstances where there's multiple defendants?
I think you've got to work out your plan of attack. You've got to find out what issues affect different parties, and focus on that as early as you can so that you can identify who it is you need to speak to and who. Sometimes you can play one against the other. Sometimes you need to deal with one person and resolve something before you can move on to the next one. But all of that, it depends on the nature of the case, but all of that is a function of understanding the issues, understanding who's who in the zoo, and coming to a game plan really early on. So you're not, halfway through the day going, I think we really need to talk to that person before we resolve this bit. You need to have that sorted out at the outset, I think. And that's why the prelim conferences are important, because you can see where everyone is and who's likely to be the driver in the mediation itself.
And just on game plan, it's really important if you're, for a plaintiff in a commercial dispute where there's multi-parties, whether defendants or co-defendants, that you allow enough time for those defendants and co-defendants to meet and to work out their apportionment, because there's nothing more infuriating when you're appearing for a plaintiff and you spend 3/4 of the day sitting in a room doing nothing whilst the defendants and co-defendants go off and work out what they're doing. I often suggest to parties that let's have 2 days, or at least the defendants meet before, and try and work out apportionment, so that when you come in at 9 o'clock or 10 o'clock for the mediation proper, that aspect's been done, and you can really start talking about the issues and the money. But a lot of people don't. A lot of people don't have preliminary conferences. When I first started out, it was a matter of course. Lawrence Street would insist upon going around and meeting all the lawyers and the clients before the mediation. Nowadays, it's rare to have a preliminary mediation conference. They should happen. It is an additional cost, but it can smooth the waters and make it a lot easier.
I think it's often a false economy not to have them, even if it's I think it should be done in person, but at least done by telephone, so that you can see who's doing what in the dispute, and try and prepare yourself properly for the mediation. I think it's a good idea to have not necessarily the defendants, but groups of parties who need to sort out an issue or some issues before anything else can happen, to have that dealt with by themselves at an earlier time, either the day before, and then kick on the next day with the rest of the dispute.
I've done this in the past, it was entirely unfruitful.
What have you
When
done?
a co-defendant sort of met in advance, tried to get a strategy on apportionment, and they're entirely cagey to the point where it was not entirely a waste of time, but could have resolved apportionment and ultimately proceeded to negotiate on a 50-50 basis, but they just were ridiculously cagey about it to the point where you're like, well, that was a waste of 2 hours. But
Well, by the same token, you could have a plaintiff and the group of defendants resolving that part of the case, and let the defendants go off and have a chat amongst themselves. I mean, it doesn't have to be one before the other, but that's just a case of looking at the particular dispute and formulating a game plan that suits that dispute and the issues that arise from that dispute, and the personalities and the jurors and so on.
I think in those cases as well, it's up to the mediator to actually do their job rather than just take the money and throw it on this.
Yeah.
So if something's going to, a page potentially going to derail it, I mean, the mediator needs to identify that early and
That's true.
deal with the issue.
No, I agree with that. And there's nothing worse, than the parties going backwards and forwards between rooms while the mediator reads the paper. You really do need to, as a mediator, it's probably more, I'm probably not the only one here, but as a mediator, you really do need to take an active interest in the dispute and make sure you are, as Mark said, making sure that you take control of the thing and ensure that it progresses. So, but the parties have a role in that as well. But the mediator certainly does. Any more?
I just wanted to explore your views about post-mediation strategies where the parties are in intractable positions at the end of the mediation and no agreement has been reached? I know it's a very, very wide topic, but are there any kind of little kind of circuit breaker pointers that you can suggest?
Sometimes, not always, but sometimes you can. You can't settle the dispute. You can come up with an agreed mechanism that might settle it. You know, you can have an agreement that somebody certifies something or somebody assess something, either binding or non-binding. But there may be a mechanism that you can put in place that'll deal with a problem that is the barrier, and then go on and deal with whatever flows from that. Perhaps, I mean, it depends. As you say, it's a broad topic. It depends on the nature of the dispute, doesn't it? But yeah, the important thing is that when you get to the end of the mediation, that you raise that very issue, and that's what today's all about. We can't give you the answers for every mediation. What we're all about today is to make people assess and critique themselves and think about things rather than just walk into a room, roll your arm over, oh, I'll tick that box, I've mediated, as the court said, and walk on, get on with the litigation. But if you get to the end of a mediation and you haven't settled and there's a problem that's stopping anything proceeding, then perhaps you can come up with a solution that doesn't settle it, but gives you a means by which you can settle it down the track.
That's a good idea.
Last calls before we have drinks.
Thank you.
Thank you very much, everyone.